Welcome to the Rapid City Zoning Board of Adjustment meeting, May 7, 2015. Some housekeeping items. If any member of the audience wishes to speak to an item on the agenda, there are speaker request forms to the left of the dais. Please fill out the request with the agenda number of the item you wish to speak and hand it to the secretary. Cell phones and electronic devices. At this time, we ask that if any member of the audience has a cell phone or other electronic device, that you either turn it off or turn the ringer to silence. If you need to take a cell call, please step out to the hallway so that the meeting will not be disrupted. Okay, we will move to the agenda. Item number 1. Second. Motion's been made by Jan and seconded by Karen to approve the meeting minutes from the April 7th, 2015 minute. All those in favor, please say aye. Aye. Now we need to have election of officers. Yes, Vicki. A what? Oh, I'm sorry. Anybody not in favor of motion in number 1? Motion passed. Sorry about that. Now we'll have election of officers.
Madam Chair, Board of Adjustment, the Zoning Board of Adjustment use the same officers as the Planning Commission. In this case, that would be Linda Marchand as chair, Eric Braun as vice chair, and Steve Rollinger as secretary.
Second.
Motion's been made by Jan and seconded by Steve for the election of Linda Marchand, Eric Braun, and Steve Rollinger as officers for this group. All those in favor, please say aye.
Aye.
Opposed? Motion passed. Now, adjustment bylaws. Vicki?
Madam Chair, that's going to be Carla.
Oh, Carla?
Thank you.
No.
I drafted some changes to the bylaws to accommodate the change of you all serving as a zoning board. We talked about this about a month ago, and I made some adjustments as a result of that conversation. So what you're voting to is approve the changes that are within the attachment to the agenda.
Motion's been made by Karen and seconded by Dennis to approve the recommended changes in the bylaws. All those in favor, please. Oh, discussion. Sorry about that. Thanks, John. No, that's great.
I saw several changes come through that were uploaded. So I just had a few questions. May I address Carla?
Yes.
The question, excuse me, I'm catching up. I think it's still page 4, section 4 on voting and declaring a majority. For matters of voting, in section 4, just for my clarification, I guess, special meetings may be called by the chair. It shall be the duty of the chair to call a special meeting when requested to do so by a majority of members of the board. Is the board 10? We don't count the alternates?
It would be 9.
It would be 9. So 6 is the number.
Well, a special meeting could be called by just a simple majority. So that would be 5.
I'm sorry, 5.
The only requirement, or the only place where you all need 6 votes affirmatively to do something is to pass a variance or to actually review the applications before the zoning board. The rest of the formal matters, adopting agendas, adjourning the meeting, those kind of things could be done by a majority of whoever's at the meeting.
Well, we don't call very many special meetings, and I guess probably I was reading that as well. In the language of this, it must be clear about the majority, because I remember all the discussions, depending on what we're voting on, what is required. So to call a special meeting is not the same as to ask for a variance.
Right, right. A special meeting is just what it is. Under state law, it's not a regular meeting, but an additional meeting. And I don't remember a time the zoning board has called a special meeting, but it's certainly an option if you would prefer to do that.
It's not that I want to change the number, I just didn't understand from the reading what majority was.
Sure.
And I wondered whether that should be specified by number in the text.
Okay.
If it isn't required by anybody but me, then I understand, but, and like I say, then the only other question I had was, on page 1, at least in the printout, in the paragraph that begins, the board shall have the power to call any city departments for assistance in the performance of their duties. I didn't understand the sentence. In the case of appeals, the board shall call upon the common council for all information pertinent to the appeal and their recommendations. Exactly, maybe somebody that's on the zoning board of adjustment could explain calling on the common council for assistance?
Well, I will tell you where that came from. That's from state law, that it provides, both of the sentences that you read are from state law. I don't remember a time when, well, first of all, we're talking about appeals here. We're not talking about variances. If you remember from last week's presentation, the Zoning Board of Adjustment does have authority over appeals of the decision of somebody, an administrative official on the zoning code. So those kind of appeals go to the zoning board. So that's what it's talking about there. So that provision.
For instance, if the council voted against somebody's petition or application, they could then go to the zoning board for?
No, that's a good question. No, that's not the case. It's a decision of an administrative official. So if the building official denies a building permit on the basis of a zoning issue, if there's an interpretation of the zoning code that somebody disagrees with, those kind of decisions would be appealed. Those kind of staff decisions would be appealed to the zoning board. I'm not exactly sure why state law talks about council here, because I'm not sure why. I guess I don't know why this language is in state law. We could certainly take it out of the bylaws.
We've never had it. It seems that it's nonsensical in its relation to the bylaws. At any rate, one last question. In the appeals section, appeals to the board may be taken by any person aggrieved by any officer. Appeals to the board may be taken by any person. It seems like appeals may be made by any person aggrieved. Is that correct?
Yeah, that's,
Instead of taken, it should be made?
if that's what you would like to do, that does make it clearer.
Vicki?
Fletcher brings out a good point. You take comments from neighbors, though, and that might be really what this is going to. If an application is submitted out and notices sent out, you're going to get neighbors in some instances that'll speak to it, and you have the ability to take any grievance from any person on that appeal.
Well, I understand the meaning. It just doesn't, taken seems to be in the wrong place there. And my comment, the reason I brought it up was, does it need to be in writing? I mean, how else does the appeal come forward through channels?
And again, that goes to the person that shows up at the meeting, just like you would if someone is bringing forward a plan development to do a use that the neighborhood has concerns with. We may not get an email, we may not get a letter, but they're going to show up at this meeting and speak to you.
So section 1 speaks to people showing up here.
Actually, this is appeals to the board. This is not a variance issue. These are the appeals that we were just talking about, where staff makes a decision and the determination is appealed to this board. So I think it would be appropriate to require that they be submitted in writing. That's not provided in there, and that's something that you could certainly change. And I think changing the language appeals to the board may be made by any person aggrieved. That's an entirely appropriate clarification.
Well, I would offer a substitute motion on the proposed bylaws regarding the in writing to, where appropriate, in the appeals to the board, with the exception of people that show up at the meeting. I mean, it clearly state that if they show up in the meeting that they can come forward. But if that appeal is made prior to the meeting, it needs to be in writing so it comes through channels and can be posted in the agenda. And also, I'd like to see that paragraph go out that makes no sense to us about the Common Council. If it's never happened, according to people that have served for a long period of time, and we don't understand what it is, I wouldn't put it in. So that'd be my substitute motion.
Just a point of clarification. Is it just the last sentence that refers to the Common Council that you'd like to remove?
Yes.
Okay. Last sentence on the bottom of page 1.
Motion's been made and seconded to remove the last sentence on page 1. And what else, John?
Under the appeals, Article 5, where appropriate, it would say that those appeals would be in writing with the exception of appeals that come forward at a meeting of the Zoning Board of Adjustment.
And then Article 5, that the appeals come in writing or people can come to the board and appeal. Any discussion? If not, all those in favor of these changes, please say aye.
Aye.
Opposed? Motion passed.
Thank you, Madam Chair.
Any other items for the Zoning Board of Adjustment? Oh, the final. We need to vote on the complete package now. We just voted on the amendment, the changes. All those in favor of the Zoning Board of Adjustment bylaws with the changes, please say aye. Aye. Opposed? Motion passed. Thank you. Now we need a motion to end this meeting.
Yes.
Is there a second? Second. Eric made the motion, and Steve seconded the motion to adjourn the meeting for the Zoning Board of Adjustment.
All those in favor?
All those in favor, please say aye.
Aye.
Opposed? Motion passed. We are now to Rapid City Planning Commission meeting, May 7th, 2015. Items 1 through 4 have been placed on the consent calendar. I would entertain a motion to accept these items. Pardon? Okay.
Madam Chair,
Yes,
I do have an item to pull from the consent calendar.
yes.
It's item number 2.
All those in favor, please say aye.
Aye.
Motion's been approved to approve item number 2. We will now handle a motion for items 1, 3, and 4. Motion's been made by Andy,
Second.
second by Steve.
Madam Chair, you already took that motion you approved the consent
Oh,
calendar.
okay.
So if you'd like, Madam Chair, I could speak to item number 2.
Okay. Vicki, would you speak to item number 2, please?
Thank you. Item number 2 is a preliminary subdivision plan for Elks Crossing. This is property located out at Minnesota Street and Marlin Drive. It's one of our areas of our city that's just continuing to grow. You've probably noticed all those new apartments that are going in out there. South of those apartments is a residential development to create 43 lots. You will see on your next agenda a couple rezoning applications that will allow for a mix of single-family and townhome development, as well as some future commercial development up closer to Marlin and Elkville Road. When we presented this staff report to the applicant, they requested that we revise two of the stipulations, just specific to timing on some things. And on the dais before you is a handout for item number 2. Stipulation number 4 goes to the vacation of the section line highway along the south lot line. They've asked that the timing be that prior to approval of the development engineering plan, instead of prior to submittal, that the section line highway issue be resolved. That will allow them a little more time to go through that process while city staff is looking at the construction plans, and then we can return red line comments. It's just kind of a coordinating issue with all of us, and they understand we'll have to suspend that application till that vacation is final, but it does get the application for the construction plans in here for us to look at. Stipulation number 7, it requires that some easements be recorded. They're asking that they be submitted for recording and that they be recorded with the final plat. What that allows them to do is to use the proposed legal instead of the existing legal. One would be a meets and bounds, difficult for the general public to track as to where those easements really are. If they can assign them specific to a lot and block, then everyone knows exactly where those easements are located. So we were in concurrence with those two requested changes, and with that we would request that this item be approved with the revised stipulations as noted on the dais.
Eric's abstaining from this, and Steve has made the motion, and Karen seconded the motion to approve with the changes. All those in favor, please say aye. Aye. Opposed? Motion passed. Thank you.
Madam Chair,
Yes,
may I address an issue before you go to the,
certainly.
it's a question really. I note that the makeup of the CIP committee has been changed by ordinance, and that the Planning Commission no longer has a seat at that meeting. Is that? It's in the process, so it has not been proposed. So I guess probably a comment while Amanda's here. These issues come before us for approval, and having sat on that committee for a number of years and understand that some of that comes back to us for approval in the process, and I see that there's some budget items in the consent calendar today. Is there still time to consider whether at least the chair or representation from the Planning Commission sit on that CIP committee?
Amanda?
That discussion has been ongoing, I know, for several months, but I see it's moving along into ordinance fashion.
Yes, at this time, I believe Monday night we did pass the first reading on changing the CIP committee makeup and also the timing of the meetings, and to allow some meetings to be able to be canceled or postponed if there's no significant changes. So it is scheduled to come back for second reading at Legal and Finance of next week, and then second reading to the May 18th council meeting. So at this time, until an ordinance is passed second reading, there's always time to change it. And you can also ask for a continuance from council members or staff, and that can also be considered too, John, so that this discussion can still be vetted out if you've got any other questions or concerns. So it is right in the middle of the process of being considered.
And how might the Planning Commission, if it chooses this morning and my colleagues agree, would we communicate to the Common Council before the second reading that we'd at least like to have consideration of a Planning Commission seat on that CIP?
It's being drafted. I think, Carla, you're drafting this one, or is it being drafted by someone else? Because you could address it, the concerns, to Carla, but then my recommendation would be to formalize or appear before the Legal and Finance Committee. That would be the next step, in my opinion.
My colleague Wade is drafting this ordinance. You could sure contact him, but I agree with Amanda that that showing up at the Legal and Finance meeting is one option you could take. or contacting your council members, that's fine too.
Because technically, John, if you appear before the Legal and Finance Committee, they can hold it in committee so that it won't go to City Council, and that gives it more time for consideration.
If something in writing was presented before the meeting and it was on the agenda, they could take action that way instead of holding it that meeting? If it were to be an agenda item?
If it is an agenda item on the Legal and Finance. So the options at Legal and Finance is to continue it in committee, which means that it would not go to City Council. It would stay in committee for 2 weeks or a month or whatever the seated committee members decide or make a motion on. If it is just an attachment and the committee members are not made aware of it, or if it's not represented by a planning commission or staff, just my opinion of way the subcommittee meetings tend to go is it gets pushed to council and then discussed there. So it all depends on where you want to really have the fruitful conversation. So if you're looking for a delay so that it can have more time for vetting, I would recommend trying to continue it in committee rather than sending it to the city council.
Okay, thank you.
You're welcome.
Madam Chairman, I don't know whether the Planning Commission wants another seat or another committee to go on. You and I have served on that committee for the last 2 years, and so a lot of very important discussions with regard to the infrastructure, which I see everyone is running for office on, is in infrastructure. And so however it arrives at Planning Commission, it will be something that has been vetted there, and to put it on consent without discussion on all of the infrastructure of the city, seems to me that somebody here should have been in those meetings and talking about it. So I leave it up to the chair to determine whether, and I think the notice to Legal and Finance ought to come from the Planning Commission, and as opposed to an individual member's asking to speak.
Steve?
I guess my question is, how did we get taken off of it? Who would address that question to?
Yeah. Amanda?
Amanda?
I was going to say, or Mr. Brewer could address this as well. In the CIP committee meetings itself is where the discussion originated on the makeup of the CIP committee, the changes, possible changes being brought forth. There was a lot of more pertinent, more detailed involvement of the planning commissioners in past CIP issues, but a lot of the changes in the ordinance and changing how the process for infrastructure actually goes through the city has been changed. There's a lot of administrative decisions now instead of actually coming before the Planning Commission. So there's not as much that goes before the Planning Commission from CIP, but as Mr. Brewer brought up, there are still some items that will come before the Planning Commission. So the discussion was also held, just to give you, I'm just going off the minutes, some of the department directors that have requests in for the CIP funds for infrastructure don't actually have a voting voice currently, and the discussion was that they would like to have a voting voice on the CIP committee. And so I think this goes back, John can correct me if I'm wrong, but I think this actually goes back, or Linda can even, 8 months ago is when this discussion first took place. And then the CIP committee currently meets monthly, and it's currently mandated in the ordinance that they meet monthly unless there is, no quorum. And a lot of times there are no updates. So the discussion also involved, can we put a mechanism in there so that we don't have to hold a meeting monthly if there's no real action and if it's just a reporting issue at that time. So those were the main points for discussion, and that's where it was turned around over to the city attorney's office to consider and take all points of the discussion and try to revise the ordinance for discussion.
I'll be honest, I think it's important that a planning commissioner or a member of this group go to those meetings. I have no problem when there's no business for a meeting, not having a meeting, because I've been to some of those meetings that have been 2 minutes, and I've also been to the meetings that have been just about 2 hours. So that's my personal opinion. John?
Thank you, Madam Chair. Over the next 5 years, on the budget that we approved in the consent, just under $125 million of projects. And those projects are infrastructure which end up one way or another before us at the Planning Commission for determination. That's the roads and the sewers and the drainage and all those things that we have to assume that staff is packaged for us well by the time it gets here. But the real work of understanding this is understanding how the budgeting goes. And it's a real flex budget. Projects get moved up and down, back and forth. And I agree with the chair. I think that it's important that one of those designated seats. Now the question is whether they're a voting member or a non-voting member appointed to that committee. I don't have strong sense that I need to be a voting member or anybody from the commission needs to be a voting member. But I think the Planning Commission needs to be an invite, needs to be part of that. They have been a voting member in the past, which means I think that they bring items to the agenda or to the discussion that might not happen if we're not represented there. So, Madam Chair, I'd recommend that through the minutes and that notice be sent to Legal and Finance for appearance representing the Planning Commission before the second reading to have the language that recognizes a Planning Commission member as part of that committee. Voting or non-voting, I'll let the council decide. That part doesn't bother me. But I think if those projects are going to impact here, and especially at the $125 million level over the next 5 years, it's just nice to have another set of eyes on it. So that's my motion, that we send notice to appear.
Second.
Motion's been made by Steve and seconded by Karen to have a member of the Planning Commission be on CIP. Doesn't, we'll have some discussion now. Karen?
Thank you, Madam Chairman. In the past, I've been part of the CIP, not anything recently, obviously, but I agree with John. I think that because we're all now part of the Zoning Board of Adjustment, and there could be some appeals that come through, and just the sense of having that connection with what's happening in our community other than just what comes before us, I think it's a good idea to have a Planning Commission member at least be there to observe, if not vote, and understand what is happening in our community, because things happen so fast that you really don't understand it unless there's an item that we have to take action on, and sometimes that big picture is not a bad idea. So I would agree with John. I think it's a good idea to have somebody there, and maybe they can, if nothing else, if the Legal and Finance Committee will send it back to committee at least to take advantage of discussing that one more time. I think that's appropriate. So I agree with John.
Steve?
I agree as well. I mean, having sat on the CIP committee at one time and also having been on the city council, that's probably the single most important board. Everybody on the city council wanted to sit on the CIP because it is probably the most important. And I'd like to ask Amanda, you being the liaison for the city council, I'd like you to take that message back to them for us, that we're concerned and we'd like to have a seat at the table. And I appreciate you being here. Thank you.
I sure will, Steve.
Vicki?
Just to kind of put this into perspective, the Planning Commission is the initial start of discussion on the city's adoption of any amendments to a comprehensive plan and or a rezone. Through that method, we are identifying the appropriate densities within an area. Without knowledge of infrastructure improvements, you may not know whether or not it's something that's timely in approving. And so I concur that even though you may not see construction plans associated with the plat, you certainly have to approve the zoning first before those construction plans would even come in. So comments well made today.
Any other comments? All those in favor of the motion, please say aye.
Aye.
Opposed? Motion passed.
Thanks, John. That's good.
We'll go to the regular agenda items. Item number 5, please.
Item number 5 is the 6-month review of a major amendment to a plan development to allow a group home for transitional housing This was previously before the Planning Commission in November and approved by the City Council December 1st, with the stipulation that a 6-month review take place today, May 7th. As of this time, the group home has not taken occupancy of the building, which I'll give you a refresher on where it's located. It's 5th Street and Fox Run Drive, office commercial with a planned development. There's an existing building located on the property. In order to be able to evaluate the impacts the use may have on the neighborhood, staff is recommending that this plan or major amendment be approved with the revised stipulation that 6-month review take place after the group home has taken occupancy of the building, so that we can actually see what the impacts are or what they may be. Are there any questions for staff? I believe there is one speaker request form for this item.
There is. We need to have the motion, and then we'll have you speak, sir. Motion's been made to approve by Jen and seconded by Andy. Kurt?
Hello, my name is Kurt Corco. I live at 365 Texas Street, and just wanted to express my support that the board approve, which it sounds like that already happened, the 6-month review period occur at the start of occupancy by Cornerstone Mission. I'd also like to add, I know that Cornerstone Mission has expressed deeply that they want to be good neighbors, and it is our hope that they embrace this also, and that we would see it as an olive branch to coming into the neighborhood. Thank you.
Thank you. Any other? John? Thank you. All those in favor, please say aye. Aye. Opposed? Motion passed. Any other items for discussion? Arla?
Yes, we're going to be talking a little bit about due process and ex parte communications. For some of you, this will be a refresher. For others, we have a few new members. It's appropriate. I don't think we've done this for more than a year. And what we're going to be talking about is just the due process clause and how that interacts with the work that you all do, and how ex parte communications kind of fits in with that. My intention of this is not to answer every question, but to just point out some of the legal issues that have to do with the considerations that you all perform, and give you just the tools to, when something is happening, maybe if a citizen is talking to you at the park or at church or whatever, it might remind you that this is an issue. It could be an issue depending on how things turn out, and just to maybe set off a red flag of warning in your head that this might be an issue, and to think about it in that way. Honestly, part of my goal is to say the worst thing that happens from my perspective is if something happens and it becomes an issue and somebody up there says, well, nobody ever told me I couldn't do that. So that's part of the purpose for this conversation, is to say our office told you this might be an issue, and hopefully deal with problems ahead of time. All right, the due process clause is in the U.S. Constitution as well as our state constitution. It says that no person shall be deprived of life, liberty, or property without due process of law. Obviously, you all aren't dealing with life and liberty, but you are dealing with property. And courts have assisted us in determining how due process applies to particular situations. Obviously, if you're on trial for murder, you have different due process rights than if you have a conditional use permit being considered by the Planning Commission. So how that actually works out in each situation has been the process that the courts have done. For the purposes of the things that you see, due process requires or includes a right to sufficient notice that's achieved through publication in the newspaper, posting of signs, sometimes mailings, depending on the nature of the application. Right to be heard, to give testimony, and to submit documents to the board that you all will review as part of the record. A right to an impartial decision maker. I've put that in bold because that's mostly what we're talking about today. A right to know the claims against one's position, a right to representation by attorney or by advocate, and a decision that's based on the evidence presented. And I know that this slide talks about evidence and testimony and attorneys, so it may imply that there's some sort of formality that's required, but that's not really the case. These can be informal proceedings. How you all do it is perfectly appropriate. And that's been found by the courts and provided in state law. It's not a court. It doesn't have to behave like one. All right, so what does due process require? Here's what the courts have said about how the due process clause applies to planning commissions and zoning boards. The commissioner must be disinterested and free from actual bias or predisposition in the outcome. There must be an appearance of complete fairness. So we're talking about actual bias and the appearance of bias. Those are both important. But generally, you're presumed to be objective and capable of judging the controversies fairly. So when a judge reviews your decisions, there's a presumption that you all did what you were supposed to do, that you were unbiased, that you were fair, that you were objective. And there needs to be some additional evidence to overcome that presumption. Courts will look at, especially in disqualifying a certain commissioner's vote, courts will look at actual or perceived interest that person might have. And they will look at financial interests as well as personal or non-financial interests. So financial interests are obviously what they say. The commissioner's own benefit, when one of you recuses yourself because you are a contractor on a particular project, that's what we're talking about there. There might be an indirect financial interest, like your employer would benefit, or maybe there's a concern about liability from a public entity, and we'll talk about that in a minute. One of the cases in South Dakota that where a planning commissioner's vote was invalidated was one where there was one of the commissioners was a waitress at a bar restaurant. I think it was in Wagner. And there was a application for another bar and restaurant, a conditional use permit for an alcohol license. She voted against that, and it was held that actually she had an interest. She had an indirect financial interest because her employer would have been burdened by this additional competition. So that's what we're talking about with financial interest. Personal interests are just interests that are not financial. Somebody, you're benefited in a non-financial way, maybe by this is something that's adjacent to your house and it doesn't necessarily affect the value of your house, but your use of the property. An indirect personal interest would be a membership in some organization. Maybe it was a year ago, we had an application, if you'll recall, from Arrowhead Country Club, and several of you recused yourself because you were a member of Arrowhead, and that was completely appropriate. Maybe not necessary, but that's certainly an appropriate response. And just a reminder, we're looking at actual or perceived interest. So they don't necessarily, somebody who's objecting doesn't necessarily need to show that you were actually biased, but it might be enough that there's a perception that you were biased. So when is recusal appropriate? These are kind of two sides of the same, or two different sides of the same coin. Recusal is when you elect to not vote on an item. Disqualification is what happens when a court reviews it and says your vote was disqualified, and it shouldn't count. So courts have said that votes should be disqualified where there's actual bias or prejudgment, where there's an unacceptable risk of actual bias or prejudgment, where your interest is different from the interest of the members of the general public. I find this to be kind of a useful barometer. You know, if you have a specific financial or personal interest in the matter that makes you have a different interest from the members of the general public. You all are up there as representatives of the public to represent them and make decisions in their interest. And so if there's something about an application that is of particular interest to you, beyond just curiosity and professional interest, that might be an area where you think about recusing yourself. And here's what the courts have said. Where a reasonably minded citizen would conclude that your interest or relationship creates a potential to influence your impartiality, then recusal is appropriate. So obviously this is, again, not showing that you were actually biased or that you were being bribed or that you had some sort of specific interest. But if a reasonable person looking at the situation, looking at the unique facts of what happened, would conclude that there's a potential that you were influenced, then disqualification might be appropriate. And just to go back to that, what courts do is they look at the facts of everything that happened. What happened before the meeting? What kind of contact there was before the meeting? What was said at the meeting? Who made the motion? Was this person advocating against or for an application? What were there communications that occurred outside of it? So all of these facts are going to be something that the court looks at to apply all of these requirements. All right, ex parte communications. The ex parte means from one party. And it's really when someone on one side of the issue talks to a decision maker, that's you, or has contact with you outside of the official proceedings. In the context of my work in the law, an ex parte communication is me going to the judge without telling the other side. I mean, that's in the context of you, it's somebody going to you to talk to you outside of an official proceeding about it, something that's before you. All right. If we're talking about one party, who is a party? The applicants and the people that they're paying to bring this application forward, their attorneys, their consultants, those are parties. Citizens who oppose, yeah, I think it's fair to assume that they are parties. They certainly have a stake, they have rights, they have due process rights. So opponents to applications, we're concerned about communications with them. It's not city staff. So your call to Vicki or Fletcher or Tim Billings or Ted or whatever, or to me, those are not ex parte communications. We work for you. It's our job to give you the information. We're not advocates. So please don't take my comments as limiting that communication at all. And we're really talking about any type of communication, however it comes in. If somebody tweets at you about something, that would be included. I mean, that's a public document, or if someone puts something on your Facebook page, but it's outside of the formal proceedings before you. So all of those types of communications would qualify. So what are our concerns? Again, our concern is the appearance of fairness and actual fairness, sure, but we can imagine a situation where, put yourself in the place of somebody who's opposed to something in their neighborhood, and they submit documents to you ahead of time. They come to the meeting, they speak for 3 minutes against this application, and then as the hearing unfolds, they discover that half of the commission has been to the site, has had personal conversations with the applicant. I mean, those are the concerns, the appearance of fairness, and they undermine the legitimacy of the commission. I don't think that's an extreme example that I don't feel like you all would ever do, but it really goes to the legitimacy of the work that you do and appearing fair and impartial. My other concern, and this is a big one for me, is if it's worth talking about with a private citizen 2 days before the hearing, it's worth bringing to the commission and sharing with everybody and having an open discussion. If it's persuasive to you, it might be persuasive to other people. And so the preference would be to bring it to this whole commission, have everybody hear the arguments for or against, have the applicant or the opponents be able to respond to the information that's being shared and have it be a part of the entire conversation. And then the other concerns have to do with due process. There's a couple cases that I'll talk about because they highlight the fact-specific analysis that takes place. And they just kind of demonstrate what courts have done in looking at it. Armstrong versus Turner County Board of Adjustment. In that case, somebody wanted to build a grain elevator outside of Viborg. And they sought a building permit. They got a building permit. They got about $40,000 worth of work done. And then the county realized that they needed a conditional use permit. So they went to them and said, stop working. Sorry, you need to go before this. In that case, it's the Zoning Board of Adjustment for the county. The zoning board denied the CUP, and then the applicant was working on an alternative plan. And in the meantime, one of the zoning board members was replaced, or there was a vacancy, and it was filled by a county commissioner whose name was Van Hove. And unbeknownst to the board, Van Hove, as a county commissioner, had contacted the grain facility, had contacted the homeowners, and was trying to work something out. And he was, the opinion makes it sound like he was really concerned about this $40,000 that they had spent, and that there might be a lawsuit and the county would be liable for issuing this building permit too early. So Van Hove was now a member of the Zoning Board of Adjustment. The CUP was before them on a revised application. He made the motion to approve the CUP. He advocated in favor of it. The motion passed 4-0. The homeowners who were upset about this grain facility sued, and the Supreme Court reviewing it said he had a disqualifying interest. He was overly involved in the matter. He was an advocate, not an impartial decision maker. And a reasonably minded person looking at this would conclude that there's a potential of, there was a potential to influence his impartiality. It made a point that he wasn't disqualified because he served in both positions. He wasn't disqualified because he had additional information as a result of being on the county commission, but really because the facts showed that he was more deeply involved. And a big part of it was that he had communicated with both sides, with both the applicant and the opponents, and he didn't disclose that. He didn't disclose it at the meeting. He didn't disclose it to the other board members. And in this case, the court totally overturned the decision. They didn't just take out his vote and say, all right, you know, his vote is disqualified, but it was otherwise okay, and the CUP can go forward. The court said basically that his interest tainted the whole proceeding, and they had to start from square one. Which, you know, some people might view starting from square one as just getting to start over, but we're talking about it's probably 2 or 3 years down the road. You know, nothing has happened. It's obviously not an ideal situation to go to court one way or the other. All right, so a more recent case that kind of resulted in, had a different result was regarding a conditional use permit in Minnehaha County. It was a conditional use permit for an agronomy facility by Colton, South Dakota, and the homeowners were opposed in part because those can be kind of smelly and have some chemicals that neighbors weren't interested in having across the road. The Planning Commission voted unanimously to approve the conditional use permit for the agronomy facility. The homeowners appealed it to the county commission. Before the county commission hearing, one of the county commissioners, whose name was Kelly, decided to call a similar facility by Worthing, South Dakota, and go for a tour and kind of educate himself about these kind of facilities. Well, it's not known, it's not clear from the record if he knew it was the same entity in Worthing that operated this facility that was trying to get another one in Colton or not. Doesn't necessarily matter if he knew it or not, but when it came to the vote on the CUP, he disclosed that he had visited this other facility. He said he was impressed by their safety and by their operations, and he voted in favor of it. There was a unanimous vote 4-0 to grant the CUP. The Supreme Court, looking at this, it didn't really decide if he should have been disqualified. The lower court said, yeah, he should have recused himself. He had an interest in information outside of the official hearing that disqualified his vote. That wasn't really appealed. But the Supreme Court did say, well, we're just going to take his vote out of the matter. There wasn't evidence in this case to show that he tainted the whole proceeding. We're going to take his vote out and assume that he should have disqualified himself, but the whole CUP still passes because there were 3 votes in favor. And that really speaks to the presumption of objectivity. There was a presumption that the court applied and said, well, unless we saw something additional, we're going to assume that the proceeding was fair and impartial, even if he was, his vote was taken out. So that, in that case, the vote was upheld. So there was all that lawsuit and appeal, and it was still the same result. As a result of that Minnehaha case that happened in 2014, this year the legislature passed House Bill 1106 that's effective in July. And it sort of speaks to these sorts of issues that we have been raising. But I'd like to just give you one caveat. You'll remember that the Due Process Clause is found in the Constitution. Statutes cannot overrule a constitutional provision. So everything that we talked about with due process still remains. The way to overrule a constitutional provision is to amend the Constitution. So this House bill, I would say, is intended to clarify some things, but it doesn't erase what I've already said about due process. But since it's new, and I thought I would share with you what it has to say. It was passed to be protective of what you all do and to provide some protection when you get information outside of the official proceedings. And there's a copy of it on the dais for you. The law says that you can receive and consider relevant information from any source. It says that you can rely on your own experience and your background. Good news. It says you can receive input from the public directly or indirectly about any matter of public interest, and such contact alone doesn't require you to recuse yourself. I don't think that contradicts anything that we've been talking about, but it just restates that you all can solicit or can gather relevant information and rely on that in making your decisions. But it also says, with regard to quasi-judicial proceedings, some additional language. You'll remember from my last time of talking, quasi-judicial really is the zoning board for the most part, but I think it's appropriate to just use the same rules for planning commission items too. It says, if an officer relies upon any evidence not produced at the public hearing, the officer shall disclose that evidence publicly, include it in the public record, and afford all parties an opportunity to respond or participate. That's just, that's, I think, a good practice. I think you all have done it in the past. Again, it just brings any information that you've had that you found persuasive or relevant. It brings it to the whole board, shares it with them, gives the people in the room the opportunity to respond. It's a good way to operate. Failure to make this disclosure may be grounds for disqualification. So the courts are still going to have to look at the details there and see just what happened and what was disclosed. And it's still going to be a pretty fact-specific analysis. But, you know, if you don't disclose it, there's a risk there. And the way to obviate that risk is to just disclose it. That goes a long way toward courts who review saying, well, it was disclosed, there's a presumption that everybody's objective and they're doing the right thing, so we're going to let it stand. And this is the last sentence of the bill. It says, so for somebody who's complaining about or who has filed a lawsuit based on a decision that you've made, they have to have clear and convincing evidence that your authority statements or actions regarding a matter demonstrates prejudice or an unacceptable risk of bias. And we've talked about that a little bit. They can show actual bias or that there's an unacceptable risk of it. So once again, this is kind of protective. Clear and convincing evidence, that's a legal standard that's higher than what you normally have to prove in a civil case. So again, that's meant to be protective of you. But it doesn't mean that in every case your actions are going to be approved. I think that Turner County case is a good one where I don't think there's anything that, any law that they could have passed where that would have been upheld. The facts in that case were pretty egregious. So what do you do when somebody comes to talk to you at church or at the softball field about the casino that's going in down the street? You encourage the person to come to the meeting. You say, if you keep talking, I'm going to have to recuse myself and then I can't vote in your favor. Give them a heads up. Like, you talking to me here might seem like a sensible thing to do, but actually it's putting me in a position where I can't advocate for you or vote for you even if I wanted to. I don't think people, you probably have run into this, I don't think people understand this. And so it can seem rude. I understand that, and I think people are used to calling Amanda and other council members. I think they might be startled when you say that you can't talk about it. But I think that it's defensible. I think you can certainly explain to them why it's putting you in a bad position. Certainly encourage, I know staff does this all the time, please put your concerns in writing, or attach them to the agenda, make sure everybody sees them. You can disclose if a communication does exist, or if you did have a conversation, disclose that at the meeting. Share it with the whole commission or the whole board. Say what was shared at that during that conversation. That goes a long way to kind of mediating the concerns. And if you feel like you're too close to it, if you feel like this person said too much, then just recuse yourself. All right, this has historically been something that we've talked about. I'm not going to tell you that you can never go drive past a site at all or look at it. I do that myself, honestly, when I'm driving around town. But if there's something that's particular to a site that you feel like you need to know, or that you feel like is really persuasive as to your vote on a matter, you can ask staff to take photos or video. You can request the photos from applicant. I know we talked about this at the last meeting regarding like the height of a sign that was higher as compared to a billboard. If that's something that you can predict ahead of time that's going to be influential in your vote, it's appropriate to ask staff to provide that, or the applicant to provide that information. If you go past a site and you find something really informational or useful to your vote, disclose and share what you observed at the meeting. Again, that's a big step to sharing it with everybody. And this gives the person a chance to respond to your observations at the meeting. And so I would say if you've driven past a site and there's something that you've viewed that is changing your mind on the vote, don't keep that to yourself. Share it with everybody. Have the chance to affect other people's votes and the ultimate application more than just your vote, and give people the chance to respond. That's all I have. Does anybody have any questions or comments or concerns?
Yes, I have one. I'm a little confused on the electronic communications that we receive. It's easy if somebody contacts me at the softball field to say, I'm sorry, I really can't listen to all of this, so I don't have to recuse myself. But I get all these emails, and they have the same information, the same debate about the facts. How do we handle that information?
Well, my suggestion would be to forward that on to staff and have it provided to all of the commission members. I know I've seen that in the past. I think that would be what I would recommend. If there's something of a personal nature that would make you uncomfortable, you can certainly edit that down. I guess what I would certainly say is don't engage in a back and forth over email. That encourages the conversation. But if there's a way to provide that information that was given to you to the entire commission in a way that doesn't, violate any sort of personal relationship that you have with them. That's what I would recommend. That's how you could bring that to light. And you could, or in the alternative, you could also, if you're not comfortable forwarding it on to everybody, you could just disclose it at the meeting and say, I was contacted by this person, these were their concerns. That's another way to go about it. Good question.
Karen?
Carla, I have a quick question. Well, I guess it's on. If there's something that we feel strongly about that will affect us in our neighborhoods, for instance, and we intend to recuse ourselves because of it, does that mean we should just state why we're recusing ourselves and not debate it at all, or not talk about it? Or can we go down in the front and be off the board for that issue and talk about it personally?
You can certainly do that. And I would say if you're going to recuse yourself and stay up there, I would prefer that you stay silent because there's a reason why you're recusing yourself. So the same reason should be why you shouldn't advocate from up there. Like I said, those court cases have looked at whether or not, a person may be, their position on it may be given additional weight because of them being a county commissioner, having some special expertise or whatever. But I would, if you would like to advocate on behalf of the position, and I've seen this from you all, coming down here and appearing as a citizen is entirely appropriate. You have that right, you have that ability. I would say just don't come here and then also vote, but you all know that too.
Don?
Thank you, Madam Chair. Carla, just to be, by the way, excellent presentation. For some of us, it is a refresher, but it was covered all the bases. Nice presentation. But following up on Karen's question, on a number of occasions, I have left the dais and gone down to advocate for. Is there any additional disclosure when we leave the dais and go down and speak in front for the record? Any additional disclosure, or just do our advocacy speech or our opponency speech and sit down?
I don't think there's anything additional. I mean, the minutes will note that you're not voting on it, that you've recused yourself. The minutes will vote that you spoke as part of the public comment. I think that's
And that we left
fine.
the dais.
And that you left the dais. Yeah, I think that's appropriate.
Thank you.
Thanks for being such attentive listeners. I feel bad getting up here and talking about the law at 7:30 in the morning. So thank you.
Carla, we want to thank you because I think it's really important that we stay knowledgeable of our duties and responsibilities, and so thank you very much. And I also want to thank all of the Planning Commission for being here today. It was so much fun to see everyone together. I'll take a motion to adjourn now. So moved. Second. Motion's been made by Dennis and seconded by Karen to adjourn the meeting. All those in favor say aye. Aye. Opposed? Meeting adjourned.